Not every business needs a patent, but every business has IP, and the most common IP that businesses have and overlook is a trademark, because that's part of protecting their brand, whether you're a landscaping company, a law firm, or an incubator. You have a brand that your customers associate with quality, with origin, with the mission statement of your company. So I'm excited to talk about that. Sam, would you mind giving me the ability to share my screen? And while Sam's doing that, just some ground rules. Obviously, as Sam said, I'm relying a lot on you to be active participants in this conversation because I'm here for a workshop. I'm not here for a lecture. And I want to make sure that you're getting the most out of this presentation when it comes to trademarks and generally some IP at the beginning. But please feel free to ask questions, alert Sam to your question, he'll alert me, and then we'll go through as much content as we can within the hour. Now, bear with me as I try and share my screen so you can see the presentation. There we go. All right, Sam, can I get a thumbs up that you can see the presentation?
Yes, we can see it, Dan.
Awesome. Well, like I said, we're going to be talking about intellectual property strategies for your business. Part two, which is building your brand through a trademark portfolio. As we go through this, I'm going to talk a little bit about myself so you know who's giving you this information. I'm going to set some ground rules on how I want you to think about trademarks. And then we're going to go into some questions and hopefully some answers down towards the end. Now, as any good attorney, I'm going to talk about myself for about a minute and a half. I am the founder of my own law firm that focuses on serving startups and small businesses throughout New York State and across the country. I do anything related to intellectual property, government contracts, SBA lending, and specific corporate matters in New York. I've been in both public service and private practice advocating for small businesses and startups. So I bring a wealth of knowledge to what we're talking about today, as well as to those other pain points for many small businesses. Here are the ground rules for today's discussion. I want you to think of business as a high stakes game. Some of us like board games, some of us like RPG, some of us like very antiquated board games. I want you to think of business as a high stakes game in any of those lenses. Your objective is to secure the biggest market share, to make the most money, accomplish the most good. Your competitors are the other businesses, the not-for-profits, the entrepreneurs. Your moves are split into defensive and offensive maneuvers. And the rounds are just the competitors and you reacting to each other's moves. If you were thinking about this as a football game, you would think about offensive and defensive lines and the different positions and the different plays that you could run on each side. That's going to give you a good lens to look at some of these IP discussions, both part one, if you go back to view that video, part two today, and then part three in a week. That's going to tell you to think about these things in an offensive or defensive position. Here's using that lens, looking at the different legal considerations for your business. I've highlighted some of the specific ones for IP, is particularly with trademarks. Registering your company's logo and securing exclusive licensing rights for a particular IP are defensive maneuvers, or you can think about them as mitigating the risk and protecting your assets. You've developed a brand, you have a logo, you have a name that's really valuable. you want to register that. You want to provide some protection for it. If you see that someone else owns it and you want it for your own business, you can try and get an exclusive license for it. On the other side, you can take some offensive or aggressive maneuvers to try and prevent your competition from getting what you have or getting what you want. You can send cease and desist letters saying that you're infringing on my trademark, you're infringing on my trade name based on common law. I want you to stop, otherwise I'm going to sue you for damages. If you see that someone's trying to register a trademark that is eerily similar to yours and might even dilute your mark, you can oppose that trademark registration at the PTO and prevent them from getting that mark, again, as an offensive maneuver to protect your market share or your share of good that you're doing in the world. For those of you who attended part one, I went over briefly all the different kinds of IP, and I'm going to do that again today and again in part three for anyone who wasn't able to attend part one or part two. The four types of IP generally are patents, trademarks, copyrights, and trade secrets. As I said at the beginning during the introductions, not every business needs a patent, but every business has IP. And that form of IP could be in any of these areas. A patent is generally protecting a technology. It's protecting your semiconductor that you've developed, protecting the process for machining something, the machine itself that's producing your widget, or if you're a pharmaceutical company or a chemical company, the composition of matter that you've formed. These patents last for 20 years, but in exchange for getting a monopoly for 20 years, you have to give the public the information. You have to tell them how to make your stuff or what your new invention is, so the public can continue to build on that knowledge. Trademark is your logo, your business name, possibly the sound associated with your business name, a fragrance, a color, each of those that distinguishes that the product is coming from you, or it's coming from a particular source, or that it has a particular quality. This is what we're going to be talking about today. And there are very, very, very few businesses that do not have a potential trademark, and probably even fewer that don't derive any value from their trademark. Copyright is anything that any expression of an idea in a tangible medium is a fancy way of saying you've put an idea on paper or into a medium that's fixed. You've put it on a CD, you've recorded a movie on tape, you've downloaded information onto a hard drive. All of those expressions could be anything from a PowerPoint presentation like this to a book you're writing or a series of books you're writing. It could be a character that you've developed for a movie or a screenplay. The copyright prevents others from stealing your idea or truly the expression of your idea. And we'll be talking about that and trade secrets in part three of these workshops. Trade secret is very similar to patent in that you have something of commercial value. It's almost like a catch-all for patent, trademark, and copyright in that you're keeping something secret because it's your edge. It's your advantage over the competition. It's the secret play in the huddle that you're talking about that others don't know. And trade secret provides you protections in case someone tries to steal it from you, and it allows you to try and get it back. Obviously, there are some restrictions on that, but a trade secret can last forever. Think about the Coca-Cola formula. That's been around since 1887. These are some examples of each of those kinds of IP. You have different kinds of patents, different kinds of trademarks, which again, we'll talk about today, different kinds of copyrights, and then different kinds of trade secrets. But I want you to remember throughout this entire workshop and through the other parts of this workshop that not every business needs a patent, but every business has IP. Today, we're going to talk about building a brand, when and how to develop trademarks. Because as I said, the form of IP that almost every business has is a trademark. And that's because that trademark is the name of your business, the logo you put on your product, the logo that's next to your name when you provide a service. All of those are protectable because it's your reputation. And building a brand is really profitable and really important to building a business. What is a trademark? A trademark is a combination of words, symbols, colors, sounds, fragrances, or other stylization that helps a customer associate a product. And by product, I mean a good or a service with an origin, a quality, mission statement, or other attributes of that product that you want the consumer to know before they buy it. Trademark rights can come from three different sources, and I want you to think about them as three different levels of trademark. You have the most basic level of trademark, which is common law trademark rights. That you get just from operating your business and being in commerce. That means that when you have a business that's operating and you're selling a service or you're selling a product, and you have your DBA, you're doing business as, or you have your company's name, that has a level of protection inherently in common law for your specific area, for your specific market. Now, some broader protection that you could get other than your specific geographic area is you could get state protection. Many states, including New York State, offer trademark registration. That registration often gives you the right to that name, to that logo, to that slogan in the entirety of the state. Meaning no one in your industry can use that mark or that name in your industry. And that ensures that you get the most market share and that you are getting the most profit from the reputation and brand that you're building. On the federal level, it gives you even more protection. So we're expanding even outward to the entire United States. If you file a trademark registration with the USPTO, you get a slew of rights, but most importantly, you get the exclusive right to use that logo, that name, that slogan, that sound, that chime, that fragrance in the entire United States for your business in your industry. And that's super important because if you start making money, a lot of money, based on a customer's association of your name with a product's quality or origin or mission, the competitors are going to see that and they're going to want to get a slice of the profits. They're going to want to get a slice of the market. And so if you haven't properly protected your name, your logo, your color, your sound that's associated with your product that tells the customer it's yours, then you're opening yourself up to someone swooping in and stealing some of your profits. There are 4 different types of marks. And I mentioned marks instead of trademarks because trademark is really just one of many marks. Think of this whole class of 4 different types of marks as marks. And trademarks are just a combination of words, symbols, sounds, colors to distinguish one's goods from another's, meaning a tangible asset like a cell phone or a cup of coffee or any other physical product that you're buying. A service mark is pretty clear based on the name. It's the same thing, a combination of words, symbols, sounds, colors, fragrances to distinguish one's services from another's. So my law firm, which you'll often see my logo in the bottom of the screen, that is a service mark technically, even though it is ubiquitously called a trademark. A certification mark is to certify that your product, whether it's a good or a service, has certain qualities or it's met certain standards. And a collective mark is the same thing. It's to show that your product has certain associations with a collective, or it's a member of an association, or it's met certain standards to be included in a collective. And there are some examples to the right of these different marks. Trademark for good, you can think of the Nintendo Switch, a video game console that you can buy that's a physical product. Amazon is a service mark technically. They provide a service. They sell products online to interested buyers. They also do a ton of other things, but we'll keep it simple for now. Energy Star Appliances. Anytime you see the Energy Star logo, it's often on different companies' products. It's on LG, it's on, Oh, I can't think of another dishwasher. It's on any kind of appliance that you're looking at when it comes to whether or not it's energy efficient. And they have to meet certain standards. By they, I mean the product. It has to meet certain standards to be an Energy Star appliance. But when a customer goes to a Best Buy or a Sears or another big box store and wants to buy an appliance and they want to make sure it's energy efficient, they will look for the Energy Star logo rather than reading through whether or not its specs meet those standards. The last one I want to go over is collective mark. And an example of that is the Independent Brewers Association. And this was actually started by the founders of Sam Adams to protect and amplify the independent brewers of America. So anytime you're drinking a specialty beer, you should look on the back of the can or the back of the bottle and see if there's this logo that denotes that they're an independent brewer and not secretly owned by one of the big beer companies. This is probably the most important slide in this entire presentation. I know it has a ton of information on it, so we're going to go slowly through this, but please ask questions if you have any at this point on anything we've gone over or about this slide in particular. When you think of a trademark, you have to think about the strength of the trademark. And the reason for that is when you are in competition with another company over whether or not they can say or use your mark in something, the strength of your mark really matters. If you look at this slide, I have some examples to the left of each of these categories that we'll go over in a minute. But you have 5 strengths of a mark. And at the bottom of the screen, you'll see generic. That is the least strong, so the weakest mark that you could possibly have. In fact, it's actually not even protectable by the USPTO because it is just describing the actual name of a product. So Daniel Kane Legal Services. It's not a very good mark. It's actually quite generic. If you're selling, to use beer as another example, if you are selling beer and you call yourself blank beer company is just generic. It's what you do. It's the service you provide or the product you make. The next level up from that is descriptive. Descriptive marks are something that describes the product's quality, nature, characteristics. And anytime I say term or word, this is really just talking about the words you're using in a trademark and whether or not it meets one of these standards. Descriptive marks are also not generally protectable by the USPTO, with one important exception, and that is if a descriptive mark has met secondary meaning, meaning that it has a presence in the marketplace that warrants protection, even though it is merely descriptive of the service or the product. Suggestive, think of a line between suggestive and descriptive. If a mark is suggestive, arbitrary, or fanciful, it is protectable by the USPTO, which is denoted by that solid line going towards strong. The dotted line is where you could have some protections if you meet additional criteria, specifically if you have secondary meaning. Where you don't have any protection is generic, as I said before. So now we've crossed into where you have protections. And the first one is suggestive. The term or word suggests something about the product, whether it's the quality, nature, or characteristics. And again, there's a couple examples on the left that I'll let you try and pick out before I go through them. But to get even stronger than that, you go to arbitrary and fanciful. Arbitrary is you've attached an arbitrary term. It's a real word, it's a dictionary term, but it has nothing to do with your product or service. Fanciful is an invented word, so it's not even a word in the dictionary. It might be an urban dictionary, but that doesn't count. It's coined, it's completely made up, and it's associated with your product. If you look at the left, if we go down from the bottom up, you're going to see the relative strength of marks, illustrated by a lot of these examples. First, you have Band-Aid and Kleenex. The reason I lump these into generic instead of listing basic products or goods or services by their generic name, these two brands are on the brink of becoming generic. Because anytime you're looking for a Band-Aid or anytime you're looking for a Kleenex, you're describing the actual product. You're not always describing the brand of product. And I'll get into genericide towards the end of this presentation. Some descriptive marks that have achieved that secondary meaning that gives them protection are Best Buy and American Airlines. If you just think about those names themselves, Best Buy is telling you they're the best buy you can get. So best price, best product, just the best buy. That puffery of best also is usually not protectable, but Best Buy has such a presence in the consumer base in society that it has that secondary meaning that they're looking for. American Airlines, same thing. They're just describing what kind of airline they are. They're American in that they originate in America, or they go to American destinations. Then you get up one more level. You get to suggestive. These are clearly protectable unless someone can make an argument that they're merely descriptive. Copper tone sunscreen is a suggestive mark because it suggests that you will get a copper tone by using their sunblock. Microsoft is suggestive because it's suggesting that the software is small. So it's alluding to how it's microchips or the really small hardware in a computer or merely the software. Arbitrary is a word that's not describing, not suggestive, completely unrelated to the product. Apple Computers is completely arbitrary. Similarly, Apple Records is also arbitrary. Zoom, which we've all been using during the pandemic, is arguably arbitrary. Video conferencing doesn't allude itself to Zoom, the word Zoom. However, you could make the argument that it's suggestive in that it allows you to Zoom quickly to other people and other places virtually. So I just highlight that one because this is a spectrum that you can slide up and down on. They don't fit discretely into one category. The one category where they do discretely fit is fanciful, so made up words entirely. Drizzly, the new beer distributor company or wine and liquor distributor, is a made up word. ExxonMobil, another fanciful, invented, coined term that has the strongest of protections because it's completely made up. When you're picking a mark, this is the biggest question you have to ask. Because if you look at the spectrum on this previous slide, as you go down, as you get towards generic, there is an increasing likelihood that another business is trying to use the same name. And the government doesn't want to give someone a monopoly on a name when other people should have rights to it. And that's where you get into this likelihood of confusion test. This likelihood of confusion is that the mark you're trying to protect can be confused with another mark or another competitor in the same industry. What I just said about the likelihood of confusion and how you can apply it to the spectrum is that there's an increased likelihood based on the strength of the mark. So if the mark is generic, it's a very weak mark, and that increases the likelihood of confusion. If it's an extremely arbitrary or fanciful mark, then there's a less likelihood of confusion because it's made up or it's complete arbitrary relation. The other criteria you should be thinking about are the similarity of the mark that you're trying to get with the marks that are already out there. You should think about the relatedness of products if they're in different industries. Today, I just saw a potential trademark for Nike automobiles. Nike automobiles obviously is not going to be too related to Nike shoes, but it is probably going to cause a likelihood of confusion because consumers associate Nike as a big company that does a lot of things. So a consumer might actually be confused about whether or not Nike Shoes is sponsoring and making those automobiles. That's where you look into the actual consumer that you're going after. What's their sophistication? Are they looking for marks when they're buying these products, or are they just buying the product? Each of these criteria are things that you need to worry about when you're thinking about applying for a trademark and if you're trying to fight trademark infringement. In both instances, you have to analyze each of these criteria and others just to discern whether or not there is that likelihood of confusion. Because if there is a likelihood of confusion, you're likely going to get rejected at the USPTO when you apply for the mark. And if there is a likelihood of confusion in an infringement suit, you're likely going to be subject to damages. Here is a really brief rundown on the steps to federal trademarks. First, can I register this? Look at the name, look at the logo, look at the slogan, look at whatever you're trying to trademark, and see if it fits any of those categories that I listed before. So trademark, service mark, collective, or certification. See what the strength of that mark is. So is it a generic mark or is it a fanciful mark? See if there's anyone else out there. This is step 2. See if there are any marks that are similar to the one that you're claiming. If there are marks that are similar and would cause this likelihood of confusion, then you likely have to figure out a different mark. Or you have to make arguments that it wouldn't cause this likelihood of confusion. Importantly, you need to decide on your industry. And I'm going to talk about this a little later in your strategic decisions. But these industry classes are really important. And so picking the right one is really important when you apply for a trademark. You file your application with the USPTO, and then you wait and respond when the USPTO gets back to you. When you file a trademark application with the USPTO, you're going to claim your trademark. So the words, how they're stylized, the logo, the symbols, the sound, the smell, whatever it is about that product, that good or service's name that you want to protect from those other competitors. You claim that on your application, and then an examiner at the USPTO reviews it for that likelihood of confusion and other criteria to discern whether or not they want to grant your registration. That process can take anywhere from 6 to 12 months, possibly longer, depending on how backed up the USPTO is in that particular industry. After all of that, if you don't get any protests, you don't get any objections or rejections, if you don't hit any other roadblocks, you'll get a registration, and then at that point, you can start using the registered R mark on your logo to show everyone that I have a registered mark. Do not try and copy me. Here are the most common pitfalls for businesses that are thinking about building a brand. First is just a failure to search. Don't assume that your business's name is available. Everyone has a bright idea, and sometimes they overlap. And so you need to make sure that you search all these available resources, the USPTO's test database, the business directories in your community, Google searches, other sources, just to discern whether or not there are similar companies in your industry with your name or a similar name. When you're thinking about similarity, you want to think about, how does it sound? How does it look? Does it have the same meaning? Is it just a translation of the word that they're using? All of those factor into this search that you're doing to discern whether or not this trademark's available. The next biggest pitfall is the failure to file. And remember where you filed. Obviously, if you wait to file, you're running the risk of someone swooping in and getting your trademark and then being left to just common law protections. But also, you need to know what level of protection you have. Common law is only giving you this little circle of protection over your specific geographic area. So don't assume that someone can't pop up somewhere else using your name, using your logo in the same industry because you don't have protections. If you file on the state level, but not the federal level, it's the same thing, just a wider berth. You're protected in your state, but you're likely not protected in other states. And so getting a federal registration is really important to getting protection everywhere in the United States. Failure to respond to the USPTO while your application is in process is a surefire way to lose a trademark registration. And on top of that, you lose the fees that you filed with that application. If the USPTO rejects your application, you have normally a few months to respond to them. You can ask for extensions in many cases, but you need to make sure that you respond, because if you don't respond, your application is going to run abandoned. And what that means is that your application was ignored, and you have to then either try and revive it for good cause, or you have to file a whole new application with new fees, and that can become very costly. The failure I see a lot after someone gets a registration is the failure to maintain. Once you get a registration, you don't just get to keep it. You need to make sure that you tell the PTO and you show to them that you are using your mark in commerce, and you need to pay to keep using your mark in commerce. So if you don't pay and you don't alert the USPTO to your continued use, your registration will expire. And once it's expired, it's free, it's game for any competitor to come in and try and get that trademark for the federal landscape, not just the specific geographic area they're in. So again, make sure that you do a thorough search before you try and file for a trademark application. Make sure that you file the trademark application in the right jurisdiction. Make sure that you respond to the USPTO when they ask for things. And make sure that you don't fail to maintain your mark. Here are the strategic decisions, or at least just a few, that you should consider with your trademark. The first one is, what kind of trademark application do you want to file? Do you want to file a 1A or a 1B? And all that is the basis for which you're filing. A 1A is available when your trademark is in use, when you've already started selling product, when you've already started doing services, when you've already started your certifications or your collective, and you file for a 1A in a particular industry. Now, if you are just starting your company, or you're thinking about expanding into a different product line, or if you're even just thinking about rebranding with a new logo, you can get protections early by filing a 1B, which is just your intent to use, meaning you have no specimen you can provide because you haven't started using it, but you want to make sure that competitors don't swoop in and steal it. So you file a 1B application that will eventually convert into a 1A application once you've started using it in commerce, whether that's selling product or providing services. Industry classes is another big one, and I actually provided all of the industry classes to the right on this slide, because your industry class dictates what market you're getting your trademark in. This is a very strategic decision for a trademark holder for two reasons. One, you're making your claim on the market that you think is the most profitable for this mark. You're also trying to prevent your competitors from getting into these markets with similar names or similar logos to try and take some of your profit, some of your market share. These can be expensive. They are, think of it this way. Every time you file for a trademark, you pay a fee to the PTO for one trademark for one industry. So if you have one trademark that's in 4 industries, you're paying 4 filing fees because they're each different industries that you're claiming in. There are 45 different ones. Most of them have some overlap, and most of them have some related products. So you have to be really strategic about what you're trying to get with your product, what kind of protection you're trying to provide for your service. Because if you don't claim the right one, someone can come in and claim the right one and actually squeeze you out of your market. This also factors into your budget. As I said, if you have one trademark that you want 10 different industry classes for, you're paying a filing fee for each of those 10 industry classes. So you have to make some strategic decisions as a company, whether you're a startup or a really seasoned small business. You have to discern what's important. You have to figure out, is the name of my company the most important thing for my customers to know it's me? Or is it the logo? Is that what they're going to look for on my product to make sure that it's from me? And based on that distinctiveness, your competition's likelihood of trying to swoop in, the overlap of your trademarks, and then the product fit, that all factors into what trademarks you prioritize. Because if you think about your mark, if you think about your brand is the name of your company. It's your logo. It's your slogan that you have under your name. It could possibly be other things about your product. It could be the sound you hear at the beginning of the show. It could be the fragrance you smell. So you have to make some really strategic decisions about when to file, what kind of application, what industries you want to claim, and then what trademarks of those I described you want to focus on. Here are some ways that you can monetize your trademark. Obviously, the first one is the most obvious. You can make your product, you can sell your service. If you do that, you'll be monetizing the trademark protection that you've gotten. The other two that I see most frequently are you could sell your trademark and you could license your trademark. Selling it is exactly what it sounds like. You sell your trademark to an interested buyer. This often happens when a company's getting acquired. So if you're a startup, let's take, for instance, Zelle. If your product is Zelle, which is to allow, as a fintech company, to allow consumers to easily transfer money quickly, and you want to get bought by Bank of America, or you want to get bought by a big bank, you then are going to need to make sure that your trademark is tied to that company and you have the proper protections for your name and the brand that you've developed that now has considerable value to other companies. Zelle is another good example for licensing. There are many banks, not just Bank of America, that have Zelle. And that's because Zelle is an example of a company that is licensing rights to use and advertise their name. Some other examples of this are Subway or other franchises. As part of that franchise agreement, they get a license to use that trademark. It might not be an exclusive license in most cases, but it's probably a non-exclusive temporary license that is revocable over the full portfolio of their brand for a specific area. Same thing with the Yankees. The Yankees license out their logo to merchandisers. So people who make the merchandise you can buy before you get in the ballpark, the merchandise you can buy in the ballpark. And these licenses are a way for the Yankee organization to monetize their brand. Another fun one is Star Wars. The Star Wars acquisition by Disney not only gave Disney the rights to the movies, but it also gave Disney the rights to all of the branding for Star Wars. And that branding is really valuable because they can license it out to toy manufacturers, to clothing manufacturers, to basically any product, good or service, that wants to use the Star Wars brand. And they do the same thing with the Disney brand. It's extremely lucrative, extremely profitable because they've developed a brand that people want to use, whether it denotes quality, origin, association, or mission. It denotes something that's valuable to that business, and so they want to license it. The two things that you should remember when you're trying to protect your brand are enforcement and then staving off genericide or generification. The first one's obvious. If you have a trademark and you've gotten protections, you need to enforce it. You need to make sure that other companies aren't using the same mark or similar marks, even if it's in a related industry, because it diminishes your mark. It shows that your mark is not that distinct. And if you ever try and enforce against someone and try and sue them, that actually your lack of enforcement can cut against you and prove that it isn't a strong mark. Because again, that likelihood of confusion really looks at the strength of your mark. And so enforcement is very important. Genericide is what I talked about a few slides ago. And that's if a mark becomes synonymous with the actual product, it can become a common noun, and those common nouns are not protectable. And so it becomes generic. It slides from possibly being completely arbitrary all the way down to generic, and means that company has lost a lot of value for that brand. A lot of companies have to stave off genericide or generification of their product because their products are either really new, really inventive, or just really popular. When you think of a Band-Aid and you ask for a Band-Aid when you get hurt, you're not saying to your spouse, honey, I need a Band-Aid brand bandage. You're saying a Band-Aid as if it is a common noun. Same thing with Kleenex. I need a Kleenex rather than I need a Kleenex brand tissue. We've also started seeing this with Google. Google is a brand. It's Google brand search engine or search engine results. To Google something, even though it's kind of used as a verb, is in the same line of possibly being generic. And if it becomes generic, Google loses a considerable amount of profit and market share because they've lost those trademark and brand rights. Some businesses that have lost their trademark are aspirin. Aspirin was started in the late 1800s for a specific kind of pharmaceutical, and it was so popular and so ubiquitous that it became synonymous with the actual pill, with the actual product. So now there are other branded kinds of aspirin. Same thing with trampoline. Trampoline was an inventive product that a company came out with using a Spanish term for a gymnastic move, came up with trampoline for a trampoline brand rebound tumbler. Obviously, we all think of trampolines as trampolines. We don't think of them as trampoline brand rebound tumblers. The most recent one that I can think of is App Store. The Apple App Store got into a tiff with the Amazon App Store because when you're thinking of applications for your phone, your tablet, for any of your devices, you immediately think, oh, I need to go to the App Store. But App Store was a really novel thing. And so Apple got the trademark rights to it when they first developed the store where you could buy apps for your phone. Amazon proceeded to develop their own app store. Android has their own app store. And it's become generic. Apple actually, in the last few years, stopped trying to enforce that trademark and abandoned it because it had become so generic. Now, that's the end of the trademark part of the workshop series. If you have any questions on trademarks, we'll address those first. And then if you want to jump back to any of the other forms of IP, I'm happy to talk about those too. But thank you again to Ignite U for inviting me to do this presentation, and I really welcome anyone's questions.
Thank you, Dan. Thank you, Dan. We have a couple questions that came in, and if you guys have any questions, please put them in the chat option at the bottom right of your WebEx portal there. You guys should see an option for chat. Throw them in there. But I have a couple questions in the meantime. Why would I trademark over a patent?
They cover different things. So it's a great question, and it pops up a lot because when especially startups are trying to think about getting investors to invest in their company, they immediately think, I need a patent. That's what they're going to want. That's what they're going to look for. But patents only cover the function and utility of a product, the design of a product, or a plant. And if it's not those three things, you can't get a patent. A trademark, on the other hand, is protecting the name, the logo, the slogan, the characteristics of that product. So a patent protects the actual making and the actual product itself, whereas a trademark is protecting your brand. It's protecting how you describe or how the consumer knows it's your version of that patented product. I hope that answers your question.
Thank you, Dan. Follow up, kind of in the same context, is do I have to trademark every patent?
You do not have to trademark every patent. What you should consider is your portfolio of products that your company is selling. If you think of let's think of a tech company. Let's use Apple as an example. Apple has a plethora of patents. It's developed a really sophisticated, diverse patent portfolio. Has patents covering its computers, its iPhones, its Apple Watches, and its other devices. Each of those patents ties to a product or a device in most cases. Those devices are then branded in different ways by Apple, and Apple chooses what to protect and what not to. iPhone is a trademark for Apple. The Apple logo appears on every iPhone because they want you to know that that device is from Apple. The Apple MacBook Pro name is a trademark because it's protecting the name of the product. So another computer company can't come in and say, we have a MacBook Pro, even though we're not Apple. I hope that answers your question, but I really want to hit home that patents cover different things. Trademarks don't cover the same things as patents when it comes to what you're trying to get, what type of protection you're trying to get. Think of it this way. A patent prevents someone from making, selling, importing, exporting your product itself. A trademark protects from others using your name, using your logo, using your brand to promote their own version of a device or service that you sell. So they're different rights, but you can use them in tandem to really build a very profitable business.
Thanks, Dan. We got some other questions coming in. This is a question for me. Fred says, can I get a copy of this video? Just so everyone knows, the recording of this video will be shared and posted on our social media tomorrow, if not Friday at the latest. You guys will see a link being posted on all of our social media channels to rewatch it on our YouTube page. We have a question from Anne Marie. Can you cover again the difference between the trademark for a logo versus a name? Does the logo and the name each need to be patented, or does the logo mark not matter as much? She kind of put a follow-up to that. Are you saying that, sorry, it keeps moving. Are you saying that you need to trademark a name and a logo separately? Did you get any of that, Dan, or should I reread that, or do you have that pulled up on your chat over there?
So I think I know where Anne Marie's going. And it's one thing that I didn't dive too deeply into on this presentation, but I'm happy to talk about. Your trademark can cover many different things, and a trademark can be many different things. A trademark could be the name of your company, the name of your product. It could be the logo itself. It could be the combination of a name and a logo. It could be your slogan in combination with everything. And these different variations, these different combinations can each individually be a trademark. So to Anne Marie's point, you could have, for instance, let's go with my company. I have the law office of Daniel Kane PLLC. The name itself is likely not protectable. It's just describing who I am and what I offer. So that in a way is a bad example, but if I wanted to try, I would get that name by itself as a standard character mark, which is just protecting the words themselves. If I wanted to protect the stylized version of it, where it has this particular font on this opening screen, I could protect that as the same trademark or a different trademark filing. I could get a trademark on this whole thing as a logo. Now that logo incorporates my name, incorporates what I do, and it incorporates the stylization of my logo. On top of that, I could also go with what you see in the bottom right-hand screen. You could also get the logo itself as a trademark, even though it is just part of the larger trademark. And this can get very convoluted very easily. So the easiest way to think about it is you have two kinds of trademarks that you can get that cover these varying things. You have word marks and you have design marks. Word marks are just the words themselves. Design marks are pictures, symbols. Any logo you're thinking of would be a design mark. File for these two things separately, or you can combine them into one big trademark application as one combined mark. If you have a whole slew of different versions, slogans, sounds, fragrances, that's all going towards building a brand. And if you take some of the big companies that you use every day, you can go into the USPTO's database and see all the different trademarks they've covered. Starbucks, for instance, has Starbucks, the words covered. Then it has Starbucks in green covered. Then it has Starbucks in its font covered. Then it has Starbucks in a logo covered. Then it has just the logo covered. Then it has a different version of the logo covered. All in the same industry, all for coffee. But they use them to their benefit. Now, hopefully that makes sense, but just keep in mind for everyone that trademarks can be the name of your business, the logo that you use for your business, your slogan, your fragrance, your sound, any of those things in combination. But each one of those is its own trademark right. Thanks again for that question.
Thanks, Dan. Brad here said the part about the sliding scale of strength of mark for trademarks was especially interesting. I'm not sure if there was a question there, but if there was any questions, Brad, about that slide, please let us know as we have a couple more minutes. I just want to address that. He found that part interesting, Dan.
Well, I appreciate the compliment.
I'm not sure if you had anything else to, maybe. No question.
He'll chime in if he has a question.
No question, just a compliment, Brad says. I just want to make sure we address that. And Anne-Marie, please let us know if we answered your question. Thank you. You got where I was going with this, she said. And Eric said no question, but just a big thank you to Dan for sharing this information. Great job. And on that note, if nobody else has a question, thank you again, just like Eric mentioned, Dan, for being here for part 2 of our IP webinar series. Some housekeeping items to end the webinar today, guys. We have part 3 next week, Wednesday at 1 o'clock. It's the final part to this series. So you guys will receive an email at like 2:30 asking you to fill out a feedback form and giving you a link to register for part 2. If you guys don't follow us on social media already, Ignite You NY, pretty much on every platform that should be consistent on LinkedIn, Facebook, Twitter, Instagram, whatever platforms you use the most. You can stay up to date on everything that we're doing, including upcoming webinars with Dan Kane and all of our other programming and resources. If you guys are a owner of your own business, your company, startup, and you guys are looking to scale and grow those operations, we are accepting applications for our 2021 Summer Accelerator program. That is an 8-week program to work with our team, our mentors like Dan, and have access to our resources to help you with your current business challenges and to help you grow and hit some of your goals in an 8-week span, but also after 8 weeks as well. As once you're part of Ignite You, you're always a part of Ignite You. So applications for those are live. Links have been promoted all throughout our social media to apply for those. And deadline to apply is June 1st, so right after the holiday weekend. And then we have part 3, like I mentioned, next Wednesday. And that should be all I have as in terms of updates for you guys. Thank you so much for being here. And Dan, thank you so much. I appreciate it. If we want to do a quick screenshot selfie so we can do a thank you on social media, Dan, we got one before, so I guess we'll do another angle in the world of
That's fine. We can do that. But thank you again to everyone for attending this session and this workshop. I look forward to talking to each of you. If you have any questions, please feel free to reach out via email, Twitter, or LinkedIn. And then also, I look forward to seeing.
Hello, Dan.
Hello?
I think you might have cut off on my end a little bit. I don't know if it was my Wi-Fi, but I got the screenshot when you were frozen. You had a perfect smile, so I pretended I was smiling too. But you were frozen for like 10 seconds, and I took the screenshot, so you're good. Well, thank you everyone for being here. Dan might be having some technical difficulties. I don't know if that's me locally or if it's Dan on his end. But thank you guys so much for being here. Thank you, Dan, again for being here. And we'll see you next Wednesday. Everyone have a safe and enjoyable Memorial Day weekend. And we'll see you guys next week. Thank you.
Thanks.
Thank you, Dan.